federal government ordered by the Supreme Court to negotiate a settlement with area First Nations. Good evening and thank you for joining us. Canada and Ontario owe nearly 150 years of back pay to the First Nations in the Robinson Treaty areas. The Supreme Court of Canada says the Crown dishonorably breached the treaties for failing to increase annuity payments. Lee Noonan has been following this story and she joins us in studio. Lee?
Thank you, Riley. As a signatory to the Robinson Superior Treaty, Fort William First Nation is party to the historic case. The First Nations along Lake Superior rejected a settlement offer and are claiming $126 billion in compensation through the courts, but this decision put a hold on that process. The Supreme Court was scathing in its decision on an appeal to the Robinson Treaty's annuities case, calling the Crown's breach of its treaty obligations egregious and dishonorable, and saying, quote, "For almost a century and a half, the Anishinaabe have been left with an empty shell of a treaty promise."
Today, the Supreme Court of Canada has made sure and expressly stated that the governments are not above the law.
In what the court calls a mockery of the Crown's treaty promise, annuity payments to the Robinson Superior and Robinson Huron First Nations haven't increased since 1875, when they were set to $4 per person per year. The country's highest court has now upheld previous decisions affirming the Crown should have regularly increased payments and now owes the First Nations.
I mean, this is, this is really positive. This is really something to be celebrated.
Fort William First Nation Chief Michelle Solomon says the decision reinforces the Crown's obligation to the First Nations and the need to hold the Crown accountable.
You're hopeful that things are going to come back in what you believe to be the right decision, the right way, the right thing to do. We all know that it doesn't always happen that way, so I'm really grateful.
The ruling lays responsibility on the Crown to augment treaty payments liberally and justly, quote, sharing the wealth of the land.
They do not have unfettered discretion to decide if there should be an annuity increase, when it should be. That matter ultimately is for the courts to decide if the governments do not act honorably.
The Huron Area First Nations already negotiated a $10 billion settlement, but the Superior First Nations took the issue to court, arguing they're owed dramatically more, as much as $126 billion. This new ruling puts a hold on that process and sends the parties back to the negotiating table with a narrow 6-month timeline to come to a settlement. Solomon won't speculate on the possible amount of a settlement or payment increase, but does say it could make a big difference in her community.
It can mean, new homes. It can mean, new opportunities. It can change the course of a person's life.
After waiting nearly a century and a half, courts also say payment should not be delayed if a settlement isn't reached or if the issue goes to judicial review. Lee Noonan, TBT News.